Members, we are now going to move on to Senate Files 458, 235, and 1359. I'm going to explain, these are the so-called gun bills. I'm going to explain what the process is going to be here, members, and then since I'm the chief author, I'm going to relinquish the chair to Senator Goodwin. Members, we have already taken, members of the audience, we have already taken extensive public testimony on the issues included in the delete all amendment that I'm going to be presenting to the committee. So we're not going to open up the floor to public testimony again tonight. We will be giving 20 minutes to each side, the proponents and opponents of the stakeholder organizations that have been working on this legislation for some time now. When that is concluded, we will discuss the bill, the proposals. We will not allow any demonstrations from members of the audience, and I make this announcement as I did at the last hearing. If you vocalize any opinions, pro or con, whatever the testifiers are saying, it will not be allowed, and the Sergeant at Arms will be asked to remove you from the committee room. We're going to have proper decorum here out of respect to the opinions of all those, even those who disagree with us. I've also been asked to make a comment with regard to physical gestures like head nodding and that kind of thing. An occasional head nod is fine, but a constant head nodding, vigorously disagreeing with something being said at the testifier table for the duration of the hearing will be considered disrespectful, and we will ask you to cease, please. And this was raised in specific reference to apparently someone was doing that at the last hearing, and it was found to be distracting to some members of the committee. So please respect the views of those who are testifying, whether or not you agree with them. With that said, I'm going to ask Senator Goodwin to take the chair.
Where'd you get it?
From the Senate Majority Research Office.
Senator Latz, will you please present Senate File 458?
Madam Chair, members of the committee, thank you very much. I'm going to tell you what I'm planning to do here so that everyone has an idea of what my proposal to the committee is. I have an A6 amendment, which is a delete everything amendment, that I'm going to be offering to Senate File 458. And I'm going to have an author's amendment to the delete everything amendment before I offer that. And then subsequently I'm going to have an amendment to Senate File 235. I'll tell you what these series of amendments are intended to accomplish. Some of the delete everything amendment that you have in your packets, which I will go through with you in a moment, captures a large portion of all of the proposals that have been brought before the legislature for purposes of reducing gun violence, making the public safer. Many of these proposals, I would say most of them, there will be broad consensus and support of, at least in the general policy, if not in the particular language that I'm proposing. It has come to our attention that some of the proposals may have a fiscal impact, that there may be a cost of implementation. So it is my intent, members, to ask the committee to pass the pure policy proposals as a part of Senate File 458, and to move or put those proposals that may have a fiscal cost into Senate File 235. Both of these files are presently bills that I'm the chief author of. And then it will be my request that the committee pass Senate File 458 as amended to the Senate floor, and Senate File 235 as amended to the Committee on Finance for consideration of whatever fiscal implications there may be. So, just to get things put into the shape I'd like to discuss them with the committee, I'm going to ask the committee to adopt the A10 amendment to the delete everything A6 amendment. But I won't ask the committee to adopt the A6 amendment as adopted or as amended until after I've had a chance to review it, and we can discuss that.
So
Madam Chair?
Senator Letts, my understanding is you want to now vote on the A10 amendment.
I move the A10 amendment.
Okay.
To the A6 amendment.
Any questions?
Madam Chair,
So this has been.
just a concern that, and I know we're going to do what you're going to do here, Senator Latz, but it's troubling that people from the general public that might be watching aren't aware of what's happening here. Things are moving very fast on these bills, and just a word of caution. I think there are a lot of people that would like to weigh in and might be very confused about what's happening here.
Madam Chair?
Yes.
I have just
Senator
tried to be
Latz.
as explicit as I can about what's going to be happening without actually going through the amendments line by line. And before I ask the committee to adopt the A6 amendment, it's my intent to go through all of the policy and all the proposals and identify what I'd like the committee to do with them so that everyone, the member of the committee and the public, is fully informed as to how I hope that we will proceed.
Okay, Senator Letts, we're ready to vote on your A10 amendment to put the bill in the shape you want it in. All in favor, say aye.
Aye.
Opposed?
No.
Motion carries.
Thank you, Madam Chair and members. Now, we've heard a lot of public testimony on these issues, and there aren't any real surprises here, I don't think anymore. But I do want to identify just a few key points for consideration. And I'm going to address my comments specifically in part to the universal background check proposal, which is a part of my proposal to the committee. There was a recent poll across Minnesota that was released by Survey USA for KSTP, which showed that 75% of Minnesotans support a background check on the buyer, including gun sales between private individuals. And broken down a bit, at 63% who consider themselves to be conservative support that background check, 80% who consider themselves to be moderate, 84% who consider themselves to be liberal. In Twin Cities, it's 81% support. In southern Minnesota, it's 69% support. Western Minnesota is 75% support. And northeast Minnesota, 59% support. Healthy majorities across the state support a background check on the buyer, including gun sales between private individuals. Members, my proposal encompasses exactly that. I want to call your attention, members, to an article from the Star Tribune. It was in yesterday's paper. A copy of it is in your packet, entitled Background Checks at Center of Legislative Gun Debate. It specifically does identify an individual who was obsessively stalking an ex-boyfriend, and she went on the internet site, arranged for the private purchase of a handgun and ammunition, was not subject to a background check, obtained that firearm, and killed her ex-boyfriend. Members, I also want to call your attention to a news release that was out yesterday from the Mayors Against Illegal Guns. This is a nationwide organization that did a study in Minnesota of a map showing that 98.9% of Minnesotans live within 10 miles of a gun dealer, demonstrating that background checks for all gun sales would be fast and easy. In other words, it would be at most a minor inconvenience to those who wish to engage in the private sale of guns. Members, I want to kind of work my way through the proposal of what I have before you. It's in the A6 amendment. Keep in mind, some of these provisions have now been removed from the A6 amendment, and when we bring up Senate File 235, I will have a motion to reinsert those provisions into Senate File 235. But I'm going to give you the thumbnail sketch, and then I'll go through these provisions item by item. The thumbnail sketch is that Senate File 458, I am recommending, contain a background check for all private sales of guns that will go through a federally licensed firearm dealer.
Yes, it looks right here.
This is essentially the proposal that was contained in what was then Senator Champion's bill as it was presented to this committee at our first round of hearings on these topics. In addition, within Senate File 458, it is my intent to include what has been referred to as the Practical Prosecutors Package, proposals that County Attorney Freeman had brought forward. There are 5 essential proposals in there, and all but one of them are pure policy proposals, do not have a fiscal impact. The one that adds to the definition of a crime of violence, the felony crime of violence statute, adds, I think it's 3 crimes to that definition. That has a potential fiscal impact because of additional beds that might be needed in the correctional facilities, and so that particular provision is my intent to have proceed in Senate File 235 and go to the Finance Committee. 458 then would also include what has been referred to as the straw purchase bill, which would strengthen the laws against people either falsely reporting the loss or theft of a firearm or acting on behalf of someone else in purchasing a firearm and then turning it over to that other person who themselves would be ineligible to purchase or possess a firearm. Those provisions are all pure policy questions. The remaining provisions will be in Senate File 235. Those provisions are mostly what is now Senator Ortman's Senate File 1325, and for the record, and I've already spoken with Senator Ortman about this, I'm going to ask the committee to give her an opportunity also to speak directly to Senate File 1325 that she worked to put together along with the NRA, and this was in large part, I understand, the contents of Representative Hillstrom's bill that has also been referred to in some quarters as the NRA bill. I know the NRA has worked closely with the authors on this, and I should note that much of it was in Senator Ortman's bill that was introduced in the Senate maybe a month ago now, of which I was a co-author. So I think that many of these provisions are bipartisan, across philosophical lines, and we can generate much consensus on these. It is my understanding that some of these will possibly have some cost to them, and so they will all go into Senate File 235 for referral to the Finance Committee. So now, for ease of identifying the provisions that are subject to all of this here, I'm going to ask you to take a look at the A6 amendment, and I will work my way through and explain to you what I'm proposing to include in this overall legislative package.
Madam Chair and Senator Latz,
Senator Ortman.
thank you. We have a summary in our packets from council that describes Senate File 458, with the A6 amendment, I believe, which I'm grateful to have, but I'm wondering, is there a similar summary for the new Senate File 235 as you intend to amend it?
Senator Latz.
Madam Chair, Senator Ortman, I know the content that's in the bill summary that you have was prepared before we determined there was some fiscal aspects to some of the provisions. So in the summary that you have in your packet from council, it refers to each of the provisions in the delete everything amendment, A6, before the application of the A10 amendment. So all of the provisions that we'll be discussing tonight are described in council's memorandum. What we don't have a separate memorandum on is the splitting up of those provisions into pure policy and possible fiscal tracks. And I will follow the memorandum from council's order as I'm working my way through the A6 amendment as well. So, members, Section 1 of the A6 amendment is taken out of, and Senator Ortman, we're going to be referring to your previous, to one of your bills, your Senate File 1359 is your other bill that's on the agenda tonight for discussion. This provision was taken from that bill, has to do with electronic entry of fingerprint and thumbprint data for delivered to the Bureau of Criminal Apprehension and making it available promptly for the database. I will note there's a 72-hour provision in there.
Excuse me once, Senator Latz, but your A10 amendment deleted section 1 through 10,
Yes,
up to 10.
Yes,
Section
Madam
9.
Chair, that's correct. But rather than jumping back and forth, for ease of following the proposals in their entirety, I'm just going to use the A6 amendment prior to its amendment, because that's where the content is all available for us to look at.
Madam Chair.
Thank you.
Madam Chair,
Senator
Senator
Ortman.
Latz, do you expect us to vote on these bills without knowing what's in each of the different bills and having an actual bill from for each one?
Senator Ortman, we have, I'm going to tell you as we're going through, and I will ask counsel for assistance with regard to which provisions are going to be in which bill. The amendments will put them in the proper bills.
But, Madam Chair,
Senator Ortman.
but we won't have two separate bills. You're going to go through what's in 458 now, right? And you're going to tell us which bill it's in under A10. But we won't be able to actually physically have these bills and know what's in them separately, other than what you tell us right now.
That's correct, Senator Ortman.
And, Madam Chair,
Senator
and
Ortman.
yet you are asking us to vote on that tonight? I think that's very complicated. I'll do my best to follow along, but I think it's unduly complicated and a very high expectation for members to vote on bills that we can't see.
Senator Ortman, I just want to remind you that the A6 amendment has been posted since yesterday afternoon, so it has been out there and available, the delete everything amendment.
Well, Madam Chair, that's true, but the A10 has not.
Madam Chair, it's quite
Senator Latz.
It's quite common practice in this legislative body to do page and line number amendments to legislation and to review them. We're very rare that we actually have a full and final version of a bill in front of us that when we vote on it. It's common to have many amendments, in fact, on bills that we're tracking through the legislative process when we take that vote.
Well, Madam Chair,
Senator Ortman.
it's not common practice to create two different bills with one amendment and not allow us a chance to look at them before you ask us to vote on them. And if you think that's common practice, I think that's not something to be proud of. I think there are a lot of people in the general public that are watching this hearing that would like to be able to follow along and can't because of this last-minute major change in these bills.
Madam Chair,
Senator Latz.
Senator Ortman, number one, you're a very smart legislator, and I'm sure that you can track all of this without any great difficulty. Secondly, about two-thirds of Senate File 235 is going to be the language that you introduced to the Senate over a month ago. Third of all of the language that is going to be presented here has been posted publicly for quite some time already. So none of these provisions are going to be a surprise to anyone. The only question is which legislative track will these particular sections follow. None of the language is a surprise to anyone, to the members of the public, to the advocates who are sitting behind me and who will testify, who worked diligently on all of these provisions in one form or another, and members of the public that have been following this discussion and the information that's been posted online relating to it. So there aren't any surprises in here, and that's why I've been very transparent. It's just a matter of logistical tracking of which provisions travel under which Senate file number. That is what's going to be before this committee.
Senator Goodman?
Senator Sharon.
I just would want to say that I do not agree. I want you to know, Senator Latz, it's absolutely clear to me what you have said, that we'll be able to see all of the language here, and that you've identified clearly that you're separating out those components that go through a finance committee from those that are purely policy. And I think that that's fairly simple to follow.
Thank you, Madam Chair. And
Senator Latz.
if Senator Orban would prefer, we can have a copy of the A6 Delete Everything Amendment annotated for her deleting the sections that will, or identifying the sections that will remain in 458 and those sections that will be going into 235.
Mr. Chair, I think that would be, or
Senator Ortman.
Madam Chair and Senator Latz, I think that would be helpful, especially for some of the folks that are here that would like to follow along.
Thank you. Madam Chair, may I describe the amendment?
Go ahead, Senator Latz.
Thank you, Madam Chair. I've already described Section 1 of the amendment. Section 2 of the amendment, also from Senator Ortman, Senate File 1359, adds the National Instant Criminal Background Check System, NICS, into the provisions for data transfer from the Department of Human Services. I will note that there is some uncertainty as to whether the Department of Human Services is authorized by federal government to direct submissions to the NICS database, and we'll be taking a look at that. That question was just raised this afternoon, and we may have to address that separately. But that came out of Senator Ortman's bill. Section 3, relating to transmittal of data to the NICS system, provides that the data shall be electronically transmitted within 24 hours to that system. So a prompt uploading of the background data relating to persons who are mentally ill, developmentally disabled, mentally ill and dangerous or chemically dependent, determined to be incompetent to stand trial or not guilty by reason of mental illness, or has their firearm possession restored under certain chapters. These are people that have been committed or judicially determined to fall into those categories. Section 4, also from Senator Ortman's bill, provides that information received by the Bureau of Criminal Apprehension that's relevant in this context shall, within 72 hours of receipt, be converted into an electronic format available for a searchable database into either a Bureau-managed or federally searchable database. And I will note that the Bureau of Criminal Apprehension has requested that rather than 72 hours, which would by its own terms include Saturdays and Sundays, that term be changed to 3 business days, so they don't have to pay overtime for people to work on the weekends to meet the 72-hour requirement. We have not incorporated that specific provision into the amendments, but it's our intent to discuss that with them and with Senator Ortman, the author of those particular provisions, and maybe clean up that detail later. Section 5, also from Senator Ortman's bill, has to do with fingerprint requirements. You'll see on page 3 of the amendment, lines 3.10 to 3.13, there's a requirement that the fingerprints and data be transmitted within 24 hours and electronically entered into the database. Section 6, also from Senator Ortman's bill, provides for the Bureau of Criminal Apprehension to convert the fingerprint, thumbprint, and other identification data into an electronic format in a searchable database within 72 hours. Section 7, also from Senator Ortman's bill, having to do with identification data other than DNA data, also has that prompt conversion provision. Section 8, also from Senator Ortman's bill, also has a prompt entry and conversion provision for information when a person is released from prison. Section 9, also from Senator Ortman's bill, requires that the court administrator, promptly and electronically transmit sentences for felonies and gross misdemeanors. And just a heads up, there's been a request that we include in that targeted misdemeanors as well, which will be possibly an amendment to add that provision. Section 10. This is originally from my Senate file 235. This is a technical addition relating to the definition of ammunition. It was intended to carry out the original purpose of the bill to clarify the definition of ammunition. Section 11, also from originally Senate file 235, adds possession of ammunition to the possession of a firearm, which falls under the mandatory minimum sentence provisions. Section 12, also from Senate File 235, is a technical addition to conform the addition of ammunition to the prohibited possession for ineligible convicted felons. And that carries us down through page 7 in Section 12. There was also a provision in Senator Goodwin's Senate File 413 relating to notification of the prosecutor when there has been a petition for restoration of the ability to possess firearms and ammunition by a felon. Under current law, prosecutors are not required to be notified of that petition. So these provisions from Senator Goodwin's bill adds the notice provision. It also establishes a more concise or standard by which the court should evaluate that petition, establishing by clear and convincing evidence that the person is not likely to act in a manner that is dangerous to the public safety, and the granting of the relief is not contrary to the public interest. We did hear testimony that a number of parties were interested in having a little clearer guidance to the courts as to how they ought to apply the standards when evaluating these petitions. And then it provides some clarification as to where the petition must be filed. And it also provides that a delay compared to current law as to when that petition may be brought. Under current law, the petition for restoration of firearms eligibility may be brought immediately upon release from incarceration. And what this provision now would do was delay that until after a person has been discharged from their sentence. So their parole or their probation has been completed, they are discharged, they're no longer on paper, if you will, and only at that time can they bring that petition. That also means that they will not be able to bring that petition while they are still on probation or parole, which gives us presumably a longer period of time during which a judge could evaluate their conduct and eligibility under the standards that are identified earlier.
Senator Latz, on that one, I just want to say that you definitely listened to the opponents of my bill on that one, and we got rid of the 10-year waiting period. You still have to have clear and convincing evidence, but in this bill, it's not the 10-year waiting period in order to apply for a gun now. It's just that you have to have clear and convincing evidence that you're going to behave yourself and not be violent again. So, thank you. Sort of.
Madam Chair, you're right. I did try to incorporate the comments that we received during the public testimony on these bills and to strike a sort of middle ground on this particular provision that I thought could generate consensus among the policymakers here. Madam Chair, on page 8, then, continuing at the end of Section 12, also part of this provision provides that a judge who takes action on this petition must report the action along with its underlying justification to the court administrator, and then the court administrator shall report to the legislature the information they've received so that we're in a position to evaluate the effectiveness of this provision. Members, Section 13 on page 8 comes from Senate File 503. This was part of the straw purchase bill, which creates gross misdemeanor and felony offenses for falsely reporting that a firearm has been lost or stolen. And as a predicate for the felony, it includes a provision, and this is on line 8.23, that the violator do so while knowing, and the language in the bill here has having reason to believe, and the amendment 810 struck the word believe and replaced it with the word know, which is a somewhat higher standard akin to a reckless disregard standard, higher than a negligence standard. And we essentially took the language out of the crim jigs for that higher standard. So it's a little lower standard than knowing, but certainly higher than simply believing.
Having reason to believe.
Members, Section 14 is a provision from the prosecutor's package that adds additional crimes to the definition of crime of violence. These are felony assault in the 5th degree, felony domestic assault, and domestic assault by strangulation. These are out of Senate File 235. Also, it provides for a second or subsequent conviction or delinquency adjudication for a violation of juveniles possessing firearms who are not eligible to do so. And here again, we listened to the testimony that was presented at the last hearing with specific regard to this. There was a concern that there might be certain juveniles that might have a first offense where it was more akin to, a kid, usually in greater Minnesota, having a gun out in their backyard shooting at squirrels or whatever, and maybe they just didn't realize it. And so if it were to come to law enforcement's attention, essentially gives them a pass for that kind of a violation, but only on a second offense. They're certainly held to have knowledge that they're not allowed to possess the firearm, and then they would be subject to this crime of violence definition, which the significance of adding the definition of the crime of violence is if they were to get a third offense, that second offense would then be a predicate for aggravating the sentence or for making determination of ineligibility. And that goes for the same with all of the crime of violence portion that's here. Section 15, also out of Senate File 235, includes that definition of ammunition into 624.712. Section 16 also amends the ineligible persons provisions to add ammunition. Make some clarifications with regard to those who are under 18. They can possess the ammunition if they are lawfully in possession of the firearm. And there are also some provisions, lines 10.20 through that page, in which the language relating to confinement as mentally ill, developmentally disabled, or mentally ill and dangerous to the public was voluntary or involuntary. It was my intent here for those who have been involuntarily committed, both for those things and also, or hospitalized involuntarily for Chapter 152 drug convictions, also as chemically dependent, that they be captured in the definitions of ineligibility for purposes of this statute. Some of those provisions also came out of the original Senate File 458. Some of them came out of Senate File 235, the prosecutor's package. Turn to page 11. You see again the addition of ammunition to the statute, a couple of places. Turn to page 12. This is also part of the same long subdivision defining ineligible persons. It incorporates some of the provisions that we've already talked about, violations of the straw purchase provisions and the transfers to ineligible persons. I will note that the original bill on this topic had a lifetime prohibition for these violations. This bill now, my proposal is that it be a 3-year prohibition. The rest on that page are essentially technical changes or amending to include ammunition. Section 18 on the next page also adds ammunition. This was also out of the original prosecutor's package bill, Senate File 235. I want to call your attention to lines 13.16 to .18. This is a clarifying definition for, essentially for the aiding and abetting provision. This language was developed with the consultation of the County Attorneys Association and the Hennepin County Attorney's Office to more closely follow the aiding and abetting language as well. And that was another piece of that prosecutor's package, was to make sure we captured those who are aiding and abetting the crimes that are also prohibited. Section 19, also out of that same package, again amends the ammunition addition to some other of the provisions of the law. Section 20, this is out of Senator Ortman's bill, requiring the prompt reporting of disqualifying mental health data when a court has made certain judicial findings, so that the data can be electronically created, and the court administrators shall enter that information into the NICS background check system, and shall also notify the person who's the subject of that report of the prohibitions on possession of firearms under state and federal law, and the laws are specifically identified there. Section 21 deals with the restoration of eligibility to those who have been civilly committed. When their civil commitment status, this defines when they can make a petition for restoration of those rights. Again, it leaves in there language relating to involuntary commitment, hospitalization, confinement. It requires that when there's a petition that is made under that provision, that the prosecutor's office be notified of that petition. That provision in particular was out of Senator Cohn's bill, Senate File 568, and requires that the standard to be applied is that the person establishes by clear and convincing evidence that the circumstances are appropriate for the restoration of their rights.
Madam Chair.
Senator Ortman.
Senator Latz, when I looked at the A10 amendment, it said that you've deleted the word involuntary. Let's see, page.
Yes,
14,
Madam Chair,
23.
Senator Ortman, that's correct. On line 23 of page 14, the involuntary word that applies to commitment is deleted, and the reason for that is that in evaluating what commitment is, it was concluded that commitments are by their nature involuntary. So the involuntary aspect really had more application to the confinement than it did to commitment. So the involuntary was deleted from that provision.
Senator
Madam
Ortman.
Chair, I don't believe that's correct. I think there can be voluntary commitment, and I think that what this does now is it reaches in further by taking out that word involuntary and applies to more individuals.
Well, Madam Chair, I'm
Senator
certainly open
Lance.
to discussing that particular provision. I honestly, I'd gone back and forth on whether to include that particular term at that location. I know there's been some input from a variety of persons on that topic as well, so I'm certainly willing to work on whether that's appropriate to have that term involuntary.
Senator Latz.
Madam Chair, Senate file, or Section 22 is also from Senator Ortman's bill relating to dealing with the background check information for persons who've been charged with committing a crime of violence who go into a pretrial diversion program to make sure that that information gets provided into the background check system, the NICS system, and provides a timeline for that to occur as well. Also, if there's been a conviction for a gross misdemeanor that disqualifies the person from possessing firearms under the enumerated statutes there, the same prompt reporting requirements. As I say, that was part of Senator Ortman's bill. Section 23, which is on page 16, has to do with applications for transferee permits and the provisions under which those permits may be permitted or denied. The language on lines 16 through 18 adopts language taken out of Representative Paymar's provisions in his bill. I should note much of that language that any place I've referenced taken out of his bill, Representative Paymar had extensive discussions and negotiations with a variety of parties that were interested in this and obtained, I am informed, consensus on quite a bit of this. So we have adopted that in an effort to capture that same consensus. That includes photocopy information, or photocopies of driver's license identifications cards or passport pictures so that identification can be properly made. Section 24 is also out of Representative Paymar's provisions on this. These are grounds for disqualifications that the chief of police or sheriff shall refuse to grant a transferee permit if that is prohibited under state or federal law, or if the transferees are determined to be a danger to self or others under paragraph B. And then paragraph B goes on to provide a bit more detail on that the decision of the chief or the sheriff must be based on documented past contact with law enforcement. So not just rumors out in the community or anything like that, but if they've had documented past contact with law enforcement, that gives law enforcement grounds for disqualifying the application for a transferee permit, then that permit shall be denied, and that the notice of disqualification should describe the specific police contact that was relied upon to deny that permit.
Madam Chair.
Senator Ortman.
Senator Latz, were those provisions heard here in the Senate? I didn't think that they were.
Madam Chair, Senator Ortman,
Senator Latz.
these provisions were, to their specific language, no, they were not. This was compromise language that was negotiated by Representative Paymar in the context of Senator Champion, Senate File 458. And I wasn't party to the negotiations. I can't vouch for exactly everyone that was a part of the negotiations, but it's an attempt to find some middle ground, certainly on this particular provisions.
Madam Chair, since these are new provisions, are you willing
Senator Ortman.
then, Senator Latz, to allow some testimony on these provisions since they have not yet been heard in the Senate?
Senator Ortman, as a part of the agenda, we have and are providing 20 minutes for the proponents and the opponents of these bills generally to testify, and I'm anticipating that those who have concerns about this particular provision will make those concerns known during that period. Madam Chair?
1 second here. This language is also similar to something that Senator Cohen had in his bill. It's not exactly the same, but it's similar. Senator Latz.
Thank you, Madam Chair. And then that provision also requires that a person who is not eligible to submit the permit application, if they've been denied, for at least 6 months since the denial. So they can't come in the day after they've been denied and apply again. They've got to wait at least 6 months. And it provides for the chief or sheriff to provide a copy of the notice of disqualification to any chief or sheriff that has joint jurisdiction over the proposed transferee's residence. Section 25 applies to the granting of permits. It's a provision that was taken out of Senator Champ, the Senate File 458 original bill. The addition on line 13 of business days for the requirement for the chief or sheriff to issue or deny the permit allows for weekends not to be counted, so they have the full amount of time necessary to make that decision. The original Senate File 458 did have a $25 fee that was included in the application for the permit. This provision deletes that $25 fee. There was quite a bit of testimony at the last hearing on these matters in which persons voiced complaints about having to, with everything else, having to add a $25 fee to their application. So we have listened to those concerns and are deleting that fee. Section 26 is in response to a proposal. I couldn't tell you exactly where the proposal came from, but I think it addresses an important concern for those situations that might be deemed to be an emergency. It authorizes the chief of police or sheriff to limit or expedite the investigation prior to granting or denying a transferee permit if the transferee requires access to a pistol or semi-automatic military-style assault weapon because of a threat to the life of the transferee or a member of the transferee's household. So, for example, if there's an active stalking situation or an active domestic dispute situation and the applicant for the transferee permit feels like they or a member of their household is in imminent need of having a firearm to protect themselves for their own defense, then the sheriff or the police will have the authority to expedite the granting of the permit if they believe it's appropriate. That emergency transferee permit expires let's see, 48 hours after its issuance, and it's not renewable. But there would be, presumably, they at the same time they could apply for a regular transferee permit, and if they pass that evaluation, then they could have a permanent transferee permit. Section 25 is taken out of Senate File 458 relating to the voiding of a transferee permit, and it's just a clarification of that the ineligibility decision will be based on state or federal law. So it captures all of the applicable laws that might apply here. Section 28 Section 28, again, takes some of the Representative Paymar language and Senate File 458 language relating to the application of state or federal law to capture all of the laws that might have prohibitions in them. requires that the person has not been denied a permit within the past 6 months, and requires the submission of accurate photographs for identification purposes. Section 29 is a combination of language out of Senate File 458 relating to state or federal law, and also utilizes the standard for notification of the transferee prohibition, the standard being that determined to be a danger or self to others. Section 30 changes a 5 business day period to a 7 business day period, and changes a 7-day period to 7 business days waiting period for the delivery of the pistol or semi-automatic military-style assault weapon to a proposed transferee. And it also includes provisions then if the chief or sheriff is unable to verify the identity, that they can notify the transferor in writing and can extend the requirements to 30 days until they're able to make proper identification. And that provision also incorporates more broadly the state and federal law as well, rather than making specific references to a section of state law. Section 31 addresses grounds for disqualification, again relating. Again, this is the same language that we've used in the earlier portion of this bill from Representative Paymar's discussions, the standard being a danger to self or others for denial of a permit, and the similar provisions relating to notice of disqualification and ineligibility to apply again for another 6 months, and a copy of the notice of disqualification to sheriffs or chiefs with joint jurisdiction over the residence of the applicant. Section 32 applies that danger to self or others standard again to the transferee permits. Section 33 provides that the transfers, transferee to transferor shall go through a federally licensed firearms dealer. That was taken out of Senate File 458. And the remaining provisions in that section also just fill in the details relating to that provision, which was identical to that was before this committee at the earlier discussion. I just want to call your attention to lines 21.19 through 33. This was a provision that exempted licensed and bonded auctioneers from being considered transferees or transferors. That was an amendment that was adopted at the last hearing on this matter. Section 34 respects the definition of relative for purposes of exclusions from the permit denial language. We listened to, and Representative Paymar listened to concerns about whether or not the definition of family, basically relative, was too constrictive. So there are some additions here, specifically the addition of spouse, aunt, and uncle to the definition of relative. Members, in line 22.16, the original Senate File 458 limited a loan between persons at a firearms collector's exhibition to 24 hours. This proposal here deletes that addition. So there will be no limitation on the length of time of a loan between persons at a firearms collector's exhibition. That was also in response to some concerns that have been raised in previous testimony. In addition, what came up during that testimony was the issue of loans between persons who were lawfully engaged in hunting or target shooting. The law currently provides for a 12-hour limit on that loan, and some concerns were raised here and with me directly after the hearing as well, that 12 hours just isn't long enough. If someone wants to lend their friend their hunting rifle for the weekend, for example, 12 hours isn't long enough. So I'm proposing to extend that to 72 hours, so to make it easier for persons to lend their firearms to friends or to relatives, rather, over the weekend. But that does presume then that the person receiving the pistol or weapon is not ineligible to possess a firearm under state or federal law. Section 35 deals with appealing the decision to deny permits. And this language was just a cross-reference essentially to other provisions that we've already identified. Under subdivision 5 is a reference on line 29. Section 36 also comes out of Senate File 458. And this has to do with the penalties for making transfers to persons that are not permitted to possess a firearm. And so the language provides that a transfer is prohibited, it's a gross misdemeanor, to transfer a pistol or semi-automatic military-style assault weapon to another in violation of this section if the person knows or has reason to know that the transfer is prohibited under law from possessing a firearm, or the transfer uses the weapon within a year after the transfer in furtherance, and they use it in furtherance of a felony crime of violence, or they've been previously convicted or adjudicated delinquent in violation of an earlier section prohibiting transfer. Section 37 comes out of Senator Cohen's bill. Line 33 deletes substantial from the grounds for granting and denial of permits, so the grounds will become there exists a likelihood that the applicant is a danger to self or the public if authorized to carry a permit, rather than a substantial likelihood. Section 38 on page 24 also comes out of Senator Cohen's bill addressing the permit to carry being voided. And the only change there is that if there's an appeal of a denial and the applicant is successful on the appeal under current law, the applicant or the permit holder is awarded costs and expenses, including attorney's fees. This provision deletes the award of attorney's fees, costs, and expenses. Section 39 adjusts the standard for review upon an appeal of the denial or revocation of a permit. The current standard of review, a burden of proof on the sheriff, is by clear and convincing evidence, and this changes the standard to a preponderance of the evidence. And on line 30, it deletes, lines 28 and 30, among the standards there, it deletes substantial again, so it's just likelihood, and it deletes investigated, so that incidents of alleged criminal misconduct that are not documented may not be considered. But it deletes investigated from that provision to be consistent with earlier changes relating to investigation being deleted. Section 40 again, these are for persons out of Senator Cohen's bill. It deletes the award of attorney's fees and costs and expenses for a successful appellant from a denial or revocation. Section 41, because there are no longer attorney's fees, costs, or expenses awardable, it deletes the provisions for the fee money that is collected to be used to pay those attorney's fees and costs and expenses. Section 42 with regard to transfers being prohibited, provides that, again, a person under current law is guilty of a gross misdemeanor who intentionally transfers a firearm to another if the person knows that the transferee is basically ineligible. The original bill added, or has reason to believe. The amendment, A10, changed reason to believe to reason to know. For the reasons I described earlier, it raises the standard for that prohibition from the standard that's was in the previous proposal. Section 43 is also out of the straw purchase bill, Senate File 503. In addition to it being a felony for the transferee to possess or use the weapon within a year after the transfer in furtherance of a felony crime of violence, it also creates a felony if the transferor knows or has reason to know, again, the correction from A10 amendment, that the transferee intends to use the weapon in furtherance of a felony crime of violence. So basically, if you buy a gun and you give it to someone else, but you know or you have reason to know that they're going to use it to commit a crime of violence, you're committing a felony as well. Section 44, also out of that straw purchase provision. I think those are technical changes to be consistent with previous changes. Section 45 comes out of Senator Ortman, Senate File 1359, relating to prior civil commitments and felony convictions. It has to do with electronic transfer of civil commitment information by the courts to the NICS database and to the BCA as well, and provides for prompt conversion of data into the proper formats. Section 46 also comes out of Senator Ortman's bill, has to do with a report by the Criminal and Juvenile Justice Information Policy Group on the success of the changes to the electronic data provisions. And Section 47 repeals of provisions in Chapter 609 and Chapter 624 that are inconsistent then with the other provisions in this amendment. So, members, I know that was long and even somewhat tedious, but as Senator Ortman indicated, I wanted to make sure everyone here and the members of the public have a full explanation of the provisions of this proposal. With that, Madam Chair, I think procedurally I'd ask that we proceed with the testimony from the proponents and then the opponents, and then we can take up the substance of these proposals as a committee.
Okay, I have Dennis Flaherty and Dave Peccia on my list. And yeah, you might as well both come up.
Madam Chair, I understand that 20 minutes will be provided for each side to present their testimony.
Thank you, and we've got
We did in
7
previous
people.
proceedings. I ask that everyone honor the 20 minutes strictly so fairness is achieved for both sides.
So we have 7 people testifying, so just keep in mind that your time is about 3 minutes.
Madam Chair, for the record, Dennis Flaherty, Minnesota Police and Peace Officers Association. And I'd be remiss if I didn't begin this evening by applauding the work of Senator Latz on this. It's quite obvious that he has spent a lot of time on this, and I'm sure he's had the help of others. But truly, he, in our opinion, has captured all of the necessary ingredients for a true piece of legislation that's desperately needed in our state. I testified previously, some weeks back before this group, and I said that the background piece of any gun bill was really the centerpiece of all legislation, and I just want to reiterate that. A lot of things being discussed is good and may help But if we really are serious about reducing gun violence in our state, this is the course, Senator Latz's course of universal backgrounds, backgrounds required on all transactions of handguns is the way to do that. And I don't want to get into statistics. You've all heard this. I really will keep my remarks very, very brief. There's enough statistics to go around on both sides. But I think Senator Latz pointed out this is really not what only the police want and feel that we need to do a good job for our citizens. This is what the citizens of Minnesota want. And they have always wanted stronger background investigations. They want to give latitude to the chiefs of police who make the decisions to grant these permits. And this bill does that. It gives the latitude to be able to deny when they have information that is substantiated and documented for reasons that this allows them to do that. And the language that was referenced on section 24, page 16, if I'm not mistaken, that language or a good portion of that came out of a meeting that was had with the chiefs in our group and NAMI and trying to come up with some language that would address the chiefs of police and their ability to simply say no to the granting of a permit to acquire handguns. And so I just think, as Senator Latz went through this, each section, each provision, I can't think of a bill that would be better than what he has here this evening. So with that, I just want to close by saying we do strongly support this, and we strongly urge you to adopt this. If, again, this is the most important of 15 bills that were introduced. The portion of this bill that provides for the requiring background investigations, straw purchases, closing the loophole with the NICS system, absolutely is what the doctor ordered for public safety. Thank you very much.
Thank you, Mr. Flaherty. And next is Mr. Peccia. I hope I pronounced that right. I know who you are, but I just don't know if I pronounced your last name right.
Madam Chair, thank you very much. My name is Dave Peccia. I'm the Executive Director of the Minnesota Chiefs of Police Association, and it's always refreshing to have the Police and Peace Officers Association supporting their chief's position on a bill. And we do support this bill specifically for the universal background checks that are incorporated in this bill. It allows the chiefs extended time to complete the background checks, and we think this is very necessary to do an adequate background check. It also allows us to consider information that we weren't previously able to use under the current law. So we are very supportive of that portion of the bill. With the additional amendments and the additions that were discussed by Senator Latz, we support those additions to this bill. We obviously are disappointed that the fee of up to $25 has been removed from the bill, as that we did extensive research and we thought that was a fair fee to charge to have the background checks completed. But having said that, the Chiefs of Police Association is firmly behind this bill and we support it, and we want to thank you for our opportunity here to speak tonight.
Thank you, Mr. Peccia. Next, we have Heather Martins.
Mrs. Chair, my name's Heather Martins.
Oh, before you start here, I just want to ask if Tom Goldstein is here and he can come up and get ready to testify as well.
I was going to ask Sammy Rahamim to come up before Mr. Goldstein.
Okay, we have him on the list as well, but instead of Goldstein?
I think we're going to run out of time.
Nope, Mr. Goldstein is here.
So,
Madam Chair?
We have done, what have we done now? How many minutes do they have out of their 20?
Let's just keep running.
Okay, all right, we'll just keep going.
so My name's Heather Martens. I'm Executive Director of Protect Minnesota, and in the interest of time, I wanted to ask Sammy Rockamine to speak briefly before I say my piece, so he's here to do that tonight.
Madam Chair, members of the committee, I've given testimony in this room.
Would you please state your name for the
sorry.
record, please? And those of you who testify, please don't forget to sign in on the sheet there.
My name is Sammy Rahamim. Last name spelled R-A-H-A-M-I-M. Madam Chair and members of the committee, I have given testimony in this room to this committee as to the devastation and trauma forced upon me and my family by the epidemic of gun violence. Against all evidence and common sense, not to mention the support of the people of Minnesota, Mr. Flaherty, Mr. Picha, the vast majority of law enforcement and clergy, there's still opposition to Senator Latz's bill. It's not easy for me to keep coming up here and to tell my story over and over again, to relive the horrific events of September 27, 2012. But I ask that you bear in mind that information as I offer some statements to explain why this bill is so necessary, why it will be effective, and what inaction will cost Minnesotans. Here are some facts. We know that roughly 1.7 million criminals and mentally ill people have been stopped from buying a gun since 1997 by a background check. What we don't know is how many guns have been bought at gun shows or different private sale transactions without a background check. Criminals use the gun show loophole and private sales loopholes to get their guns, and then they use them to kill and injure other people. 80% of criminals who committed a crime with a gun said that they used this gun, they acquired this gun in a private transaction without a background check. Transactions that, if this bill passes, those criminals would undergo a background check. The reality is that closing the gun show loophole and expanding a simple system that works will respect, not encroach, our Second Amendment rights. 91% of checks are completed instantly, and records are kept by the folks who run them, not the government. Background checks protect Second Amendment rights of law-abiding citizens and serve a patriotic purpose, making sure that we have one system for those of us who want to purchase a firearm, not two. One for those desperate to avoid detection and bent on violence, and one for everyone else. We deserve the right to safety. At the time of the shooting, I had just finished applying to various colleges. My dad, who was an immigrant and never really went to college, was really big on me, getting into good schools, and was something that he wanted to be proud of for me. I never got to share the news of my acceptances with my dad, something that I had always looked forward to when I first started my education. This is just one of many life experiences that I will have to go through without my father. Too many Minnesotans have and will be robbed of their family members, and with the support of this bill, I believe you would be remiss to not vote for it. My father, Reuven, and the 5 other fathers murdered at Axe and Signage, Rami, Jake, Ron, Eric, and Keith, along with all the other past and future victims of gun violence, deserve your vote, an epidemic that you can slow.
Thank you, Mr. Ramin. Do you want to add to that, Ms. Martins?
Yes. How much time do we have? Just
10 minutes.
We have about 10 minutes left.
Okay. All right.
And after you two, doesn't count when I'm talking, we have 2 others.
Okay. Again, my name is Heather Martens. I'm Executive Director of Protect Minnesota, working to end gun violence. I'm here tonight I'm going to address some of the new provisions in this bill, which we very strongly support as do our membership. And I think what we need to realize is that times have changed and our laws have not kept up with the level of firepower that is available out on our streets today. We are not talking about your father's hunting rifle. In fact, this bill only applies to pistols and assault weapons. And I think that's been overlooked in some of the discussion, because pistols are most often used in crimes, and assault weapons are most capable of helping someone commit a mass murder. What we are looking at is the firepower that used to be available only in combat situations is now available readily on the commercial market since the expiration of the assault weapons ban in 2004. What we're seeing is an escalation in in the dangerousness of the weapons that are available freely on the market. And it's important our laws keep up with that. In 1994, the United States passed the Brady background check bill. As Mr. Rockamy mentioned, it has stopped over 1.7 million purchases of firearms to people who were not eligible to have them. And that is true even with the flaws that exist in the federal system. What was left out of that federal law was the private sales. It was gun shows, and at that time, the internet was not an easy source of buying anything. Now, the internet sales are a huge part of the commercial market in just about everything, and as I have found on the internet myself, there are sites that are very much kind of like the Craigslist sites, although not Craigslist, that offer pistols, that offer assault weapons, that offer specifically the Bushmaster that was used, the same type of firearm that was used in the Sandy Hook shooting. All of that is available as a private sale online. And so it is possible to just click on a private sale on one of these websites, arrange to go meet the person that is offering that firearm for sale, and go get it, and there's no background check required. That is perfectly legal today, but that needs to be eliminated. That is not right, and it is an easy loophole for people to take advantage of when they have criminal intent. Many people are astonished to hear that that's true. In fact, when I stated that to the media a couple weeks ago, I was inundated with emails from gun rights individuals saying that's not true, and in fact, it is. Unbelievable, but true, and this bill would fix that. The other large gap in our background check law is gun shows, and this is something I've also experienced. I've been to a gun show in Anoka where typically most of the sellers at the gun show are licensed dealers, but all you have to do is go to the back of the armory, and there are several tables of people who are unlicensed sellers. So when I went to that gun show, I spoke to a seller who had a number of pistols, and he also had a couple of Uzis, which are assault weapons. And I asked him about the Uzi, and he offered that Uzi to me for cash with no background check, and that is perfectly legal today. And that is wrong. That should not be available to anybody who walks into a gun show. We do know that these loopholes have been exploited, as is noted in one of the news articles. Mrs. Rochelle Inselman exploited the loophole to obtain a gun even though she was prohibited from buying one, and then committed murder with the firearm. We do know that garage sales in Pillager, Minnesota, as reported in the Star Tribune, were a source of illegal guns that ended up on the streets of Minneapolis and were used in crimes. So we know these things are exploited, and we know that this gap needs to be closed. There's some dispute over how many guns are sold that way, and the reason we don't know the answer is because there's no regulation of those sales. We do know that estimates of 40% of sales were made, and that those are there, and that was before there was internet. So I think that that number may have gone up. I don't know, but I think it's significant enough that we should address it. We do have a right to be safe in our communities, and I think that this is something that we must never forget, and we must never forget the grief and the devastation that our families right here in Minnesota go through. About 350 people die every year from gunshot wounds. And those people never come back. Their families are never the same. It's a sad thing that we in the United States have to live with a 7 times higher homicide rate than other first world countries. That homicide rate is driven by a 20 times higher gun
Ms. Martins, I think
homicide
you're going to
rate.
have to wind it up here.
Okay.
Sorry to cut you off, but
All
we
right.
do have 2 other people.
Okay, so shall I, 2 other people for us? Okay, well, they-
Yes, and that would be Mary Louise Groh from the League of Women Voters and Vic Rosenthal. You don't want to testify? Okay, then it would be Mary Louise Groh. Is she here?
Yeah, she's here. She'll cede her
Oh,
time.
you're
She's
giving
ceding
your
her
minutes to Ms. Martins, both of you, or?
It's time, come on up.
You can come up, and I'll take Vic's time, I'll take Tom's time and finish with this.
Can I give you my time? I'd like to give you my time.
Okay, sure.
All right, they have forfeited their time to Ms. Martins. Go ahead, Ms. Martins.
Okay.
I think we have, what do we have left?
I would like to share a story about what it looks like to live in a safe community. There has been discussion of other countries and how they do actually respond when there are terrible situations like the Sandy Hook shooting, how there is more attention paid to gun access in other first world countries because guns are, when they are used in an assault, they end in death far more often than other means, other weapons. I would like to share a story from an experience that I had while traveling in Germany. There was in a town about the size of Minneapolis. I read the paper one morning and there was a story about a robbery at a convenience store. The robber came into the convenience store and he said, "I have a gun, give me all your money." And the owner said, "You do not, get out of here." And the robber said, "How about a loan until the end of the month?" And this, if you can imagine, if we could live in a community where we felt safe enough to do that, wouldn't we all be better off? And I would like you to ponder that as you consider this.
We have probably about 1 minute left here.
Okay, all right. I would also
Overstated the
like to
time.
just briefly address the question about whether extending an existing system, which we now have, a federal background check system, would suddenly, if we just extend an existing system, which we are using and have been using since 1994, to more sales, that somehow that is gun registration. I would just like to point out that there is no government record kept currently because Congress requires that the background check record be destroyed within 24 hours, so there is no record kept. Currently, if the same system were applied to more sales, there would still be no record kept at the federal level. And all that is kept currently is a transaction number, and that is used if a gun is traced to a crime to connect the transaction with the serial number of the gun. The federal government then has to call the dealer who sold that gun and ask them who bought that gun originally. And unfortunately, often the trace is not successful because the gun has been passed off in a private sale.
Okay, thank you, Ms.
Okay,
Martins. We will have some testimony from the opponents. I have here Chris Rager and Joe Olson. I think I got your name wrong, Mr. R-A-G-E-R.
Rager, that's right, Senator. I'm Chris Rager at the National Rifle Association. I appreciate the opportunity to speak to members. I wanted to start by naming a couple things that we have issues with in the bill. I obviously don't have time to go over all 44 sections like my friend Senator Latz did, but there are a number of things in the what I would call the Latz gun control bill that have lot of concerns for myself and my membership. First, in Section 10, I noticed that they don't use the full ATF regulatory definition of ammunition, and that's something that might be interested to take a look at. I'm not sure why that wasn't included. I don't think that the County Attorneys Association had an issue with that provision that was in the Ortman and Hillstrom bill. In Section 16, I noticed that Senator Latz gets rid of the term judicial determination and talks about individuals who are ineligible to possess a firearm based on an involuntary hospitalization. I guess the concern there would be, are we talking about individuals who perhaps are on a 72-hour hold, in which case that would be considered a involuntary confinement. Those people would be released from that hold, and based on the language I see here, they would probably be prohibited from possessing a firearm. In Section 21, I think what Senator Latz is trying to do there is, again, take apart from the Hillstrom-Ortman bill that deals with the implementation of the NICS Improvements Amendment Act, and he does not actually capture all of the necessary components to make Minnesota compliant with the federal law. And I think that that would be something that is better handled, actually, in the Ortman and Hillstrom bill. In Section 24, we've got a concern there because what's going on there, we're talking about a transferee, making the transferee permit from a shall issue state to a may issue state. Right now, there are over 30 states that don't require their citizens to have to beg the government for a permit just to possess a firearm in their own home. And what we're doing here is we're going the complete opposite direction. Rather than moving away from a permit system and strengthening the background check system so there isn't a duplication between the chiefs of police and the FFLs that also do background checks, we're making a system where, based on past police contacts, we're going to be denying somebody a fundamental right. And we can't quite tell because there's no definition of what past police contacts could mean. We're not talking about any types of charges, any types of convictions. It's merely you could have been an ornery teen, and all of a sudden the local chief of police has a foul on you. Now you're going to be denied a permit to exercise a fundamental right. So that's obviously a concern of ours. In Section 25, we see the arbitrary increase from 5 to 7 days to process a permit, and even allow up to 30 days.
Sorry, you got about 15 seconds left on your 3 minutes, unless somebody else is going to forfeit that for you.
We got 20 minutes, right?
Madam Chair,
Senator Limmer.
didn't the proponents have 20 minutes?
We're
And
gonna
they
give
could, and they could divide that time any way they want?
Absolutely, and so can they.
Why are you limiting him to 3 minutes, Madam Chair?
Because I want to know. I just asked a question, Senator Limmer. If he wants to stop in 3 minutes, or if he wants somebody else to forfeit their time. I don't know what they've got planned.
Madam Chair, I think that we might have only 3 testifiers,
Thank you.
so I think that
Then you can go ahead.
all right, appreciate that, thank you. I was talking about the arbitrary increase from 5 to 7 days for the processing of a permit to a transferee permit, and then allowing potentially up to 30 days because you can't identify somebody. So I could see a lot of room there for there to be chiefs of police and maybe sheriffs who just go ahead and use that full 30 days and basically create a 30-day waiting period. Then we'll get into the main thrust of the Latz. The Latz gun control bill is the quote-unquote universal background checks or the private sales bans. This part of the bill would unnecessarily abolish private transfers of handguns and certain semi-automatic rifles. This would prohibit the now lawful trades and sales between your hunting buddy, your buddy down at the local gun club, or even certain members of your family. And it also impose a new $25 fee on each transfer. And there's also a situation where you can only borrow your buddy's hunting rifle for 72 hours. So let's use an example of what we're talking about there. You have an individual who goes, borrows his friend's Beretta or Benelli shotgun and decides to go down to Louisiana to shoot some mallards. And he's obviously going to be there for more than 72 hours. So when he goes to borrow his friend's shotgun, he has to do a background check and pay $25. And then when his friend comes back with that firearm, he has to do a background check, do $25, and you have to organize to meet up at that gun shop or an FFL. That's obviously an unnecessary burden on law-abiding folks. It was mentioned that 70% of the public here in Minnesota support universal background checks, and I think that really goes to the question that's asked in that poll. And if you would ask people what what they thought about having to ban the occasional sale of a firearm between their best friends or their hunting buddies, I think you get quite a different answer. Or if you'd ask them what they thought about instituting a universal registration scheme, because otherwise the universal background check system is useless, they'd probably have a different opinion on that. It was also mentioned that there's the private sales loophole. Here in America, it's always been allowed to occasionally sell or trade or borrow a firearm, obviously within the scope of the state and federal laws. Private sales are the exception, and they aren't the rule. Research shows that we're talking about likely less than 10% of firearms are sold without background checks. It's also important to note that firearm ownership is at an all-time high right now in America, and violent crime is at an all-time low. To speak specifically to the universal background checks, they aren't universal. By the plain terms of the bill that Senator Latz has put together, there are people that are exempted from those background checks. I think it's pretty obvious to note that criminals aren't going to all of a sudden submit themselves to background checks because there's expanded checks now. So you're creating a regulatory scheme that only burdens the law-abiding citizens that are already doing background checks. It's also not surprising that despite extensive research, there's no study that has shown that expanded background checks would lead to a reduction in violent crime. In fact, the universal background checks would not only be an inconvenience for law-abiding citizens, the delays and complications could lead to increases in violent crime. Like I mentioned, the universal background checks are unenforceable and would likely have to lead to registration. The Obama administration in January 2013 study actually admitted that the effectiveness of universal background checks depends on requiring gun registration. So, and the reason that is because the whole point of this expanded check or this private sales ban is to track the transfer of firearms, and you can't track the transfer of firearms if you don't have any type of paper trail. And without state law enforcement doesn't have the ability to access the NICS background check system unless there's a bona fide criminal investigation. So basically, you're instituting this scheme that will only impact the law-abiding. I think it's also important to note that it's already a felony to be engaged in the business of buying and selling firearms and ammunition without having a federal firearms dealer's license. It's already a crime for a federally licensed dealer to sell a gun without doing a background check. It's already a felony to sell, trade, give, lend, rent, or transfer a gun to a person you know or should have known is not legally allowed to own, purchase, or possess a firearm. And the penalty for selling to a person who is a criminal, a mentally ill, mentally incompetent, or an alcohol or drug abuser is a 10-year felony. So I think it's important to point out that criminalizing private transfers through a system of so-called universal background checks would not have prevented any of the tragedies that have spurred the call for this legislation. Even if accomplished by a change to create universal registration, most criminals' possession of firearms would remain outside of such a system. So I think it's important as members of this committee review this legislation. We also take a look at the Senator Ortman's bill that I know that Senator Latz and others have collaborated on as well, and take notice that there are over 100 members of this body that have supported that legislation, and I think it's worthy of the discussion that they'll get tonight and consideration on the floor that I'd like to get. Thank you.
Thank you, Mr. Rieger. Is it Professor Olson?
Yes, it is. Thank you. Thank you very much, Madam Chairman. And I'd like to start off by thanking Senator Latz for listening to some of the things that I said at the last meeting and making some changes in his bill. Unfortunately, there aren't enough changes. And I'm going to start actually by talking about some provisions that I really can't understand. If you look in sections 37 through 41, there are changes to the carry permit system, which no one has asked for. The sheriffs, we negotiated all of those provisions with the sheriffs. They agreed that they could carry the burden. They agreed that they could meet the standard of proof. They agreed that it was perfectly all right for successful permit appellees to recover their attorney's fees because the money doesn't come from the county budget. The money comes from the permit fees that comes from people like me and all of these folks in purple shirts who go down and pay $100 to the county to get a carry permit. the money comes out of that fund. It comes out of our pocketbooks. So the reason for eliminating the attorney's fees seems to me to be just sort of gratuitous nastiness. It was agreed to by everyone in 2003. It was agreed to by everyone in 2005. The sheriffs have never asked for a change. And there are no complaints. It's like somebody just looked in the bill and said, where can I find some things where I can hassle permit holders? And so that's essentially what we have there. No complaints, negotiated language, language that's been in place, a language that doesn't cost the county anything because people like me pay the fees. So that's the first thing that I would like to talk about. Second thing I would like to talk about is if we look on page 10, you'll see that we have involuntary confinement added to the list of a number of things that disqualify you from being able to own a firearm. I have a question for Senator Latz. Does that cover a 72-hour hold where the person who makes the determination that the person needs to be confined is not a mental health professional but a police officer? And because I've had cases where people were put on 72-hour hold, they got to the hospital, 20 minutes later they were seen by a board-certified psychiatrist who had a cup of coffee with them, who said at the end of his 20 minutes, there's nothing wrong with you, you've had a bad week. Here's some Valium, go home and get a good night's sleep. And that was probably the only person in the county who had a recent determination of sanity, yet he had been involuntarily confined by the police officer. And if those sorts of holds are included in this, we have somebody who is sane, has never been unsane, who's going to have to spend $3,000 to go and get his rights back through...
Professor Olson, what is your question for Senator Latz?
My question is the 72-hour hold covered?
Senator Latz.
Madam Chair, Professor Olson, yes, it's intended to cover 72-hour holds.
So it would...
Professor Olson.
Sorry, Madam Chairman, Senator Latz. So someone who has in fact never been determined to be mentally ill, developmentally disabled, or mentally ill and dangerous to the public by any kind of mental health professional would lose their rights and then have to go through the expensive process of getting them back?
Senator Latz.
Madam Chair, Professor Olson, they would, under the proposal here, yes, they would lose their rights, and they could appeal that decision. How expensive that is depends on how they choose to go through that process.
Well, it's a court process, so at least there will be a couple of $100 in fees by the court system, if nothing else.
Professor Olson,
I'm sorry.
I don't know if there's a follow-up question. The point is that better be safe than sorry. There'll be probably more people that are confined for the full 72 hours than who are released in 20 minutes.
All right.
Professor
Madam-
Olson, please keep your comments to the chair and
Yes,
the committee rather
yes.
than Senator Latz.
Yes, I haven't been here in a good number of years. I used to be very good at this, Madam Chairman, Senator Latz. Well, I think that is a serious problem that we have because it's a process that's totally without due process. So you can be picked up by someone who is untrained. You can be confined by someone who's untrained. You can be determined by someone who is trained that there's nothing wrong with you. And you lose your rights for having nothing wrong with you. I think that's wrong, and I think that's something I'd like to talk with you about changing. Lastly, how much time does our side have?
Thank you. There's about 6 minutes left.
6 minutes left. I'll just say one thing about the universal background checks. There is registration attached to them. This is a federal Form 4473. If the transaction goes through a dealer, which it's required to do, one of these forms will be filled out on every single transaction, and these forms ultimately wind their way to the ATF, where they go into a computer bank in West Virginia. So yes, it's permanent. Yes, it's a registration system. It's just a little bit clunky, but it's there.
Thank you, Professor Olson, and please state your name for the record.
Madam Chair, my name is Jim Nash. I'm the mayor of Waconia. I'm pleased to be here this evening, and I've been asked to cede some of my time, so if I could ask the timekeeper to show me when I've got 2 minutes, and then I will cede the rest of my time.
And we will give you an extra minute or two because we did the other side. So let's say you have 7 minutes.
Unnecessary, I will cede my time to some other folks, but I appreciate the opportunity to be here tonight, and I'd like to bring sort of a common sense approach to this. I would categorize myself as the average gun owner in America who has had that tradition passed on to him or her by their family, and I myself have passed that on to my own children. My wife and I have 6 children, and all of us enjoy hunting and recreational shooting, and I'd like to think that because of that, I have what I would view to be the average Minnesotan's view on this. We enjoy spending time at the gun range, in the deer woods, grouse hunting, pheasant hunting, and so on, and we feel that our Second Amendment rights are that. They are a right that has been afforded to us, and we feel that many of the things that we've heard tonight are overreaching and impinging on our Second Amendment rights. And as an aside, and respectfully, I would say that in many ways, I would echo what Senator Ortman said earlier this evening, that the shuffling around of amendments and pieces and moving parts, to me, strikes me very much as a bit of a game of 3-card Monte that I saw played once in Central Park in New York. I'm an educated man, I've got a master's degree, and I think I'm pretty smart, but sometimes it's very difficult to follow things, and I think that we as elected officials owe it to our constituents to provide them as much clarity and transparency as we possibly can. I think that the true assessment of my view on this would be in support of Senator Ortman's bill, that there are things that need to be tightened up. And as you may remember, there was a case in Carver County with a gentleman named Christian Oberender who had been previously committed and convicted of murder. And those things are the things that we need tightened up. We don't need more gun control. We have plenty of gun laws. You could place all of them on this table, and I think it would strain under the weight of the gun laws that if you printed them out on paper would be sitting in front of me. What we need is criminal control. We need to understand the true nature of what's going on in front of us. We've heard lots of testimony about criminals doing this and criminals doing that. Let's focus on them. Let's not overly burden the people who are law-abiding, Second Amendment enjoying citizens. I myself am very, very anal when it comes to obeying the laws that I have in front of me. And I know very many of the people who I'm friends with feel the same way. And before I finish and see the rest of my time, I would like to point out that this isn't discussing just semi-automatic assault-style weapons and pistols. There was a piece in here, Senator Latz, in Section 34, Section 6, where you talk about hunting rifles. I myself am a proficient hunter, and I have loaned out my hunting rifle. And respectfully, deer camp often lasts longer than 72 hours. And it is these types of things, the lack of common sense, that I would urge you to not support this bill, because common sense should rule the day here. This is not a common sense bill. People in Carver County and all over Minnesota, in counties across the state that you folks represent, lots of them own guns, and they're obeying the laws and they're following the rules. Let's not overly burden them with excessive rules, tacked on more excessive rules on top of more excessive rules. Thank you very much.
Thank you, Mr. Nash. And next testifier, please state your name for the record.
Mr. Nash. How much?
Mr. Nash.
My name is David Gross. I'm with the Gun Owners Civil Rights Alliance. I'm from Faribault, Minnesota. My comments will have to be necessarily brief. I think this is a very well-crafted bill. The problem is its purpose and what all that craftsmanship went to. At every opportunity, it deprives people of their 14th Amendment rights to life, liberty, and property, to the right not to be deprived of life, liberty, and property without due process of law or equal protection of the laws. That's independent of the Second Amendment, which create presumptions, heightened scrutiny, a presumption that people have the right to keep and bear arms. And this bill tries to reverse those presumptions. It openly does so. There is nothing subtle or clever about this bill. It is very open with what it's trying to do. And very skillfully, it tries to do it. So it takes a situation where a person is deprived of their liberty, a commitment, for example, without due process of law, and then tries to deprive them further of another civil right without due process of law. It's the proverbial catch-22. It's almost Orwellian. It's frightening. The bill has a lot of doublespeak. It creates vague, unenforceable standards. It grants discretion, unbridled discretion to law enforcement to deem something necessary. It uses the word deem and does not provide standards. It makes a mockery of the appeal process. And as Professor Olson indicated, there was a contract, there was a deal where sequestered money from the permits would be used to secure the civil rights of appealing people.
I'm sorry, sir, you just have
We're
about
done
1
now,
minute.
huh?
No, you've got another minute.
Okay. That fund was set up precisely to pay for the process of determining civil rights. So when you take, for example, the denial of a permit and the focus of the appeal, the sheriff now has a clear and convincing burden of proof. That's being proposed to change to the preponderance. But heightened scrutiny of the Second Amendment requires a heightened burden of proof. So to do that is to defy the heightened scrutiny of the Second Amendment, a civil right. You can't argue the Second Amendment anymore. We have the Supreme Court decision in Heller. It is a fundamental, individual, enumerated right. That calls for heightened scrutiny, not heightened undercutting. I guess
Thank you. Your time is up. Thank you very much. Senator, with that, the opponents and the proponents have had the time. Sorry, we have to limit time, but we have a couple more bills on our agenda yet tonight, and Senator Latz would like to wind up this one, I'm sure, and go on to his next one. Senator Latz.
Thank you, Madam Chair and members. I'd like just to make a couple of comments in response to what I've heard, and then I'll make a motion, or the committee can proceed with its deliberation. I think there appears to be a misunderstanding, as Mr. Rager was suggesting, that this bill proposes to ban transfers. It does not. It does not propose to ban transfers. It simply proposes to provide what I would term a very minor inconvenience of going through a background check before being able to engage in that transfer, a public safety-related background check. And I'm not sure where the addition of the $25 fee is in connection with that. The proposal refuses to either mandate a fee or not from a private licensed firearm dealer, but it certainly allows for that fee to be charged if the firearm dealer wishes to do so. We have control over whether local governments can do the fee, but we're not proposing to mandate anything with regard to a fee for the firearms dealers themselves. Mr. Rager said that we're proposing to give exemptions for family members. Therefore, we're not making this universal. Well, it seemed to me making exemptions for family members was something that the NRA and gun owners wanted us to do. And now that it's included in the bill, even broader than was in the original bill, we're being castigated for it as somehow no longer being universal. So I don't think they'd appreciate it, nor would Minnesotans, if we closed that loophole. So I'm not going to propose to do that. The point is not to track the transfer of firearms. The point is to do a background check on the transferees. That's the point, is to keep the guns out of the hands of people that are ineligible to possess them. Now, Professor Olson raised the issues of attorney's fees, and it sounds like he's opposed also to using, to including the confinement language, involuntary or not, in that. And I will indicate I'm open to working on those provisions. I'm open to discussing those provisions. I may be persuaded by Professor Olson's comments on those. Mr. Nash did make a comment that a 72-hour loan was not enough. Well, I can always delete that provision of the bill, and then current statute at 12 hours would remain in effect. I thought I was trying to accommodate the interests of gun owners by extending that to 72 hours, but I guess we can see how the process goes. And I would respectfully submit to Mr. Gross that there is no Second Amendment issue here. I would say, first of all, the Second Amendment is not absolute. The Second Amendment does not guarantee absolutely everyone the right to have unfettered access to firearms. We already know the Second Amendment does not guarantee the right of people convicted of felony crimes of violence to possess firearms. There isn't any dispute over the constitutional law on that question. Similarly, with those who have been committed for having severe, significant psychiatric disorders, mental illnesses, all we are seeking to do is to provide a system by which that information is better communicated to the existing background checks, whereby we are actually able to have meaningful, yes, discretion on the parts of the chief law enforcement officers in the state, the police chiefs and the sheriffs, to not only learn about but evaluate the significance of those kind of mental health issues and backgrounds, and yes, contacts with the police departments, in determining whether someone is just that cranky teenager who once had contact with the police, or whether the crankiness was a symptom of some ongoing issues that maybe the neighbors would prefer that cranky teenager or now young adult not have a .45 Magnum in his possession when he's walking down the street. I don't think that we can legislate for every particular fact situation, but I think we can legislate some standards and have some trust in our chief law enforcement officers to apply those standards to individual circumstances with the due process rights of appeal. So, members, we're going to be faced with a choice here. We can close the gap in background checks. It's a little bit like building a dam that's 60% across the river. 60% of all private sales now of firearms are covered by background checks because they go through licensed firearm dealers. The other 40% aren't. If you build a dam only partway across the river, the water's going to find a way around the dam to go down the river. You've got to not only shore up the dam that you have, which is a lot of what Senator Ortman's bill does, but also build the dam the rest of the way across the river so that you, in fact, are capturing all of those ineligible persons in the background checks. Another analogy that I've heard before was if people are boarding an airplane and they only had 60% of the passengers go through the security screening at the airport. The other 40% could just walk right on through and get on the plane. Would you be comfortable getting on the plane knowing that's the security situation? I submit the strong majority of Minnesotans would not be comfortable with the analogous situation in background checks for purchases of guns. The fact is, gun violence is an epidemic, members. There are 1,000 deaths a month in this nation from guns, and they are mostly not the horrific mass shootings that we read about in the papers and see on TV. They are mostly in ones and twos with pistols on the streets of our communities. We have the opportunity here to make a meaningful and very low burden background check to try to stop those who are ineligible from possessing firearms from getting them. And I ask for your support for these bills in their entirety. That said, Madam Chair, I will ask the committee if you'd like to have some further discussion on it, and then with the time as appropriate, I will move the A6 amendment as amended.
Oh, thank you, Senator Latz. And let's try to get through this quickly if we can, please. Any questions from members? Senator Limmer.
Thank you, Madam Chair. Senator Latz, early in the evening, you established the rules of play for the people assembled here. But I've never once heard a chairman of a committee say that the people of our state couldn't even express an opinion by nodding their head. I've never even heard that. You know, after all, these are American citizens, and I suppose we're talking about the Second Amendment. I hope we aren't talking about the First Amendment. I've never heard that in 25 years of being in office. Now, there are times when people get a little riled up, and we want to tone down the rhetoric and keep the discussion to a reasonable effort, and we really do not appreciate loud protest. But the nodding of a head, I can't believe I heard that this morning, or this afternoon.
Madam Chair, may I respond?
Yes, Senator Latz.
Madam Chair, Senator Limmer, I was actually passing along a request from one of your Senate Republican colleagues on this committee. So perhaps you ought to direct your concerns to your colleagues that were distracted by it.
Madam Chair.
For what it's worth. Maybe I should have screened that out.
Madam Chair.
Maybe an appropriate background
Senator
check would
Limmer.
have been
Madam Chair, whether it's
but I take your comments to heart, Senator Limmer.
whether it's a Republican or a Democrat, nobody should deny our people a right to express themselves. And we shouldn't be so sensitive that if someone's sitting across the room and they disagree with something I say, I better pay heed to that. And I think we're beginning to, maybe the session is getting a little long and we're beginning to bump into each other a little bit. But I think we all should have a reason to pause and remember who we're working for. The other comment I'd like to say is that after looking over your bill and knowing where the votes are in the Senate as well as in the other body, I think we have a bill that's not going to pass. And so all the effort that we've been putting into this, all of the headlines, all of the attention to the gun issue, I think will be for naught due to your bill. I think you've created too heavy of a bill to be carried by, and I'm usually pretty good on head counts. I don't think it can pass out of the Senate. And I would even doubt even more somewhere else in this building. So I don't know what we're trying to accomplish here if we aren't trying to work on something that everyone can agree with.
Senator Ortman.
Thank you, Madam Chair. Senator Latz, I consider this to be a hostile takeover of my bill. I don't support what you're doing with my work and the work of others that helped me to learn about these issues, especially about the NICS index. I also think it's hostile for you to refuse to take a vote on my bill, Senate File 1359, and put it on the agenda as only discussion, because I believe it would pass this committee, and I believe it would have strong support in the Minnesota Senate. But more importantly, Senator Latz, I believe this effort is hostile to law-abiding gun owners in the state of Minnesota. It's also hostile to their personal property rights. But more importantly yet, it's hostile to the principles of the Second Amendment, which creates a right of gun ownership, not a privilege. It imposes on Minnesotans' rights. So, under your bill, if I understand it, you're going to try and regulate those private transactions between private individuals over their backyard fence. You're going to try and extend the time for our law enforcement to decide when a person has a right to a gun or not through the permitting process. You're going to extend that up to 30 days. You're going to create discretion where there is none now under Minnesota law. When we passed the concealed carry law, we all agreed that the law enforcement should have a shall issue requirement so that there wasn't discretion, so that the sheriffs and the chiefs weren't making arbitrary decisions, that it wasn't one way with one applicant and another with another, and that their personal relationships wouldn't get in the way, that they would be required under Minnesota law to fulfill the right when someone does apply for a permit. And instead, now you're going to require them, not even may, require them to look at all prior contacts with individuals who apply for a permit and consider them in a permit application. And when you do that, you've asked them to consider contacts that have never been through the due process requirement. They're not even arrests. They're just contacts. They're completely unreliable in determining the basis for denying someone their constitutional rights. And then even worse, you impose on folks, individuals with mental illness, Madam Chair. No due process. So we may have returning veterans who won't want to get help, who won't want to go to a 72-hour hold. They might fear that they might not be able to then exercise their Second Amendment rights. You've changed many of the legal standards. It seems to me, Senator Latz, that this is a very selfish act here, because I think that this committee would pass Senate File 1359. I think that it would. I think the Senate would. We should be targeting gun crime and not law-abiding citizens. We should crack down on straw purchases. We should improve the state and federal background check system. We should improve the reporting for court-determined mental health disqualifications and create a process for restoration of rights. We should strengthen the penalties on felons and repeat criminal offenders. We could do all that without imposing on the Second Amendment rights of law-abiding residents. We don't need new restrictions on gun purchases or ownership. We don't need any kind of impact on law-abiding citizens. We don't need universal background checks. We don't need to repeal or roll back the shall issue law of the concealed carry. And Madam Chair, Senator Latz, members, I wish that you would put Senate File 1359 back on the agenda for tomorrow. This committee could still pass a bill that Minnesotans could believe in and support.
I think,
Madam Chair.
members, I think we're ready to vote.
Sure.
Okay, Senator Lynch, you want to wrap it up?
Yeah, because Senator Ortman has taken it upon herself to accuse me of being hostile on a couple of points, including on refusing to allow us to vote on her bill. Madam Chair, as an act of professional courtesy, I agreed to put on this agenda a bill that was just introduced this week by Senator Ortman. An extraordinary accommodation, because most bills that are introduced at this point in session when the policy deadline is Friday don't have a snowball's chance, and you know where, of getting on a committee's agenda. And Senator Ortman specifically requested that I put this bill on the agenda, and I indicated to her that I would do so with the express opportunity for Senator Ortman to discuss the bill and to identify the provisions about her bill that she's most concerned about. And for that professional courtesy, she's saying, I'm being hostile by not putting it to a vote. Senator Ortman, next time I will know not to put your bills on the agenda at all when it comes in this late in the session, because now I am being castigated for it. So, and I'm not even going to address your accusation of this being a selfish act. But I will say that Senator Ortman is a lawyer. She knows what due process is. And this bill is replete with due process. The Constitution and our statutes are replete with due process, where in certain circumstances a property right is taken away from an individual, and post-deprivation there is judicial process to have the constitutionally mandated review of that circumstance. And I can start listing all the places in statute where that occurs, but there's no point in doing that. The fact is, this is not about due process. This is very simply a question of whether or not law-abiding citizens ought to have the minor inconvenience of having their background checked before they are able to purchase a product which, used for its intended purpose, will kill people and other things if it's used in that manner. Seems to me that is a very minor regulatory addition to our fabric of laws to protect the public safety.
Thank you. Senator Latz, okay, I think we're ready to vote.
Roll call, Madam Chair.
Madam Chair,
Roll call has been requested.
Madam Chair, I move the adoption of the A6 amendment as amended.
Okay.
Madam Chair, I wish you invoke Rule 12 of 10, which would put record the vote in the Senate Journal.
Okay,
3 hands is required.
all right, 3 hands. I see 3 hands. Okay, 3 hands I see. We'll put it in the journal. We are ready to vote in the A6 amendment. All in favor, say aye. Aye.
There was a roll
Roll
call,
call
ma'am.
on that, too. Okay, sorry, missed that. Take a roll call.
Senator Latz,
Yes.
Senator Hall,
No.
Senator Ortman,
No?
Senator Cohen,
Yes.
Senator Limmer,
No.
Senator Goodwin,
Yes.
Senator Sharon,
Yes.
Senator Dietzick,
Yes. There being 5-3, the amendment is passed. Senator Latz, to the bill.
Madam Chair, I move that Senate File 458, as amended, be recommended to pass and be referred to the Senate floor.
Okay, Senator Latz's amendment, all in
A
favor?
roll call, Madam Chair.
Roll call has been requested.
And and invoke the 1210 ruling again, Madam Chair.
Okay, if I see 3 hands? 3 hands, okay, we'll do that. Now, we'll have a roll call.
Senator Latz,
Yes.
Senator Hall,
No.
Senator Ortman,
No?
Senator Cohen,
Yes.
Senator Limmer,
No.
Senator Goodwin,
Yes.
Senator Sharon,
Yes.
Senator Dietzick.
Yes. Okay, Senate File 458 as amended, it's recommended to, it's passed and is recommended to go to the Senate floor. It will move to the Senate floor. Thank you.
Madam Chair, for Senate File 235.
Oh, I'm sorry, the vote was 5-3.